Prosecutors want communication privileges taken from Kelly Bryant. That's that Pontiac mother accused of abandoning her children for years. She faces child abuse and welfare fraud charges now. Investigators claim that they have jail records showing that she's contacted her children's caregivers multiple times now to talk about the case. Doing so would be a direct violation of a judge's order.
Bryant's 3 children were found living in filthy conditions after they say they were abandoned nearly 5 years ago. Prosecutors are now also seeking to terminate her parental rights. Her next scheduled court appearance is April 15th. And joining us now to talk about the case is attorney Rick Convertino. Thanks so much, Rick, for being here. So will she have her communication privileges revoked, do you think?
I believe so, especially in a case like this where she was warned by 2 judges on 2 separate occasions, the last being by Judge Thomas when her bail was reviewed and lowered. Judge Thomas warned her specifically not to have any contact with anyone under 18. Specifically, don't talk to your children, don't talk to the caregivers, and wanted to restrict the possibility of her intimidating witnesses. So she made a clear and conscious effort to directly warn her, and Ms. Bryant did the very things that she was warned not to do.
Yeah,
there will be consequences.
Things really don't look good for Kelly anyway, Rick.
No.
Obviously, she's not having the best
an
case.
understatement.
Yeah. So for her to do this, why even take the risk when things are already so bad? It's going to only make it worse.
Oh, she must. I mean, there must be some mental imbalance or some deficit that would allow her to do this. Otherwise, it's the intentional flouting of the judge's direct orders and the terms and conditions of her bond and bail terms is categorically idiotic. So. Yeah, there's no upside to what she's doing, that's for sure.
And these conversations are recorded when you're coming out of jail. Do we know the content of the conversations at this time, and will they be used against her in court?
It appears that the conversations were between her, her caregiver, and her children, and then other inmates at her direction, and they occurred between March 8th and March 12th. There were about 10 calls that took place during that period of time. And yeah, they most assuredly were recorded and maintained, and that's the basis upon which Ms. McDonald, the prosecutor, went ahead and made the motion in court to have her communications restricted.
Yeah, there's so much about this case that you just can't believe, can't comprehend.
Yeah, 3 years. These kids were alone for 3 years in this condo. It's outrageous to use that overused
totally
lawyer
outrageous.
term.
Yeah, and for her to just do this, you know, we can't get into her mind obviously, but it just seems like, is there any remorse there, or are you accepting any kind of accountability for her actions? If anyone is trying to defend her, how does this hurt them now moving forward?
It doesn't help any lawyer whose client is disavowing and flouting the terms and conditions that a court imposes on him or her, so it makes it much more difficult to defend. But that's not even the underlying case. The underlying case, the facts are horrendous in this case, including I think 4 counts of first-degree child abuse, which each count being a life term for serious mental harm and distress that she imposed upon her kids over that 3-year period of time. And then recently there were 4 additional fraud counts resulting from the checks that went to sustain the children that she took and converted for her own purpose.
Is there a mental competency, or is there some sort of insanity plea that she can make at this time, or is that calculating when it comes to the fraud?
Well, that's a very good question, actually, because that you can make a not guilty by reason of insanity. That is a separate and distinct, kind of like the Miller hearing. It would be separate and apart from the trial itself. Before the trial, they'd have her examined at the forensic center. A state forensic examiner psychologist would give her an examination and make a determination, and then she could have her own forensic psychologist examine her, and then that would all be hashed out prior to a trial if that were her defense, and then the judge would make a determination if that defense would be allowed at trial. So it's a pre-trial defense, and a determination will be made prior to the trial whether she can proceed with that at trial. If not, that can't be raised at trial. But your point is well taken and very good. That'd be conflicting with the child abuse, the intentional and willful and knowing fraudulent activity that occurred, which would obviate the mental infirmity.
Yeah, we have to wrap things up, but I really want to ask quick, for those other inmates who may have helped her, could they be facing some trouble too now?
They could be. There could be an aiding and abetting charge. There could be separate charges brought, and it could affect their terms and conditions as well, pretrial release if there were any, bond conditions if there were any. So yeah, those people, the consequences are certainly right around the corner for them.
Well, Attorney Rick Convertino, thanks for joining us.
That's a pleasure.
As always, such a pleasure having your analysis
Thank you.
on these
Thanks.
topics.
Thanks to both. Thanks.